Under the Freedom of Information Law, if a request is made from police departments for all civilian complaints about police officers, can those agencies refuse to comply for not substantiated complaints? To find out, you have to read New York Civil Liberties Union versus City of Rochester, but it's 7 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of New York Civil Liberties Union versus City of Rochester. The citation for this case is 2025 New York Slip Opinion 01010, published by the New York Court of Appeals on February 20th of 2025. The issue in this case is whether, under the personal privacy exemption to the FOIL law, to the Freedom of Information law, our agencies, our police departments, allowed to categorically withhold all disciplinary records related to law enforcement that are not deemed substantiated. To explain all that in a few moments, I think the background that's helpful to understand is that the Freedom of Information law is a statute that basically it allows civilians, people, to submit requests to the government for public documents from governmental agencies. So you can request, from the Census Bureau or from the Tax Bureau or from the police department, all kinds of documents under the Freedom of Information law. And they have to respond and provide you what you've asked for unless it's protected by a certain exemption or exception to FOIL. Until the year 2020, disciplinary records of law enforcement officers were categorically exempted from that public disclosure by FOIL. But in June of 2020, George Floyd incident happened. He died in Minnesota at the hands of police officers. There was public outcry that law enforcement agencies were not appropriately handling allegations of misconduct against police officers. And New York legislature responded to the George Floyd incident by repealing civil rights law. They did a lot of things, but they repealed Civil Rights Law 50A and amended FOIL to specifically address and allow for disclosure of law enforcement disciplinary records. Okay, so what are the facts in this case? The facts are that after the 2020 amendments, the New York Civil Liberties Union submitted FOIL requests to the City of Rochester and the Rochester Police Department. Those requests asked for records of all civilian complaints against Rochester police officers from January of 2000 onward, regardless of whether they were deemed substantiated or not, resulted in disciplinary action or not. And to be deemed substantiated means that they were investigated and found to have occurred, or substantial evidence that they occurred. If they were not deemed substantiated or deemed unsubstantiated, after an investigation, they were not found to have substantial evidence that they occurred. Doesn't mean it didn't happen. It just means that the investigation did not reveal that it happened. Okay. Rochester, in response to those FOIL requests, did not produce the requested documents. So the petitioner, the New York Civil Liberties Union, commenced an Article 78 proceeding to compel them to disclose under FOIL. In response to that Article 78, the Supreme Court ordered Rochester to produce the documents, but said that Rochester could withhold all records that are not deemed substantiated under Public Officers Law 87-2B. The NYCLU appeals to the Appellate Division, and they modify the decision. They say the personal privacy exemption does not authorize Rochester to categorically withhold records that are not deemed substantiated, and then it gets appealed to the Court of Appeals. And here we have a unanimous decision by the Court of Appeals, and their decision basically reaffirms the point of FOIL. They say FOIL is designed to promote open government and public accountability. There's a duty imposed by FOIL on government agencies to make the records available to the public to the maximum extent possible. And this is the quote: "These official secrecy is anathema to our form of government." And basically they say the personal privacy exemption exists under the amended statute to allow an agency to withhold from public access any record if upon disclosure, it would constitute an unwarranted invasion of personal privacy. And law officers can use that exemption, but it can't use it in a blanket way. There's no such thing as a blanket exemption under FOIL, is what the holding from the Court of Appeal says. To the contrary, the FOIL law as amended requires that disclosure be made of complaints made about officers regardless of regardless of the outcome of the accusation or the proceeding. So rather, agencies are required to provide the FOILed documents either without redaction or with redactions they can substantiate and specifically justify on each individual case. And that's the case of New York Civil Liberties Union versus City of Rochester. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.